What did Donald Trump do today? April 24, 2025 recap. This morning's Truth Social post from Donald Trump exemplifies several of the recurring issues that characterize his social media rhetoric. Inflammatory language, logical incoherence, personal grievance-driven attacks, and a reckless disregard for the implications of his statements on civil discourse, democratic institutions, and the rule of law. First, the post's central claim that Harvard is an anti-Semitic far-left institution is a sweeping generalization unsupported by specific evidence in the message itself. This kind of broad-brush accusation, especially when leveled against an entire university community, not only misrepresents the institution but also inflames public sentiment without offering a substantive critique or engaging with factual complexities. Like many universities, Harvard includes diverse political viewpoints among faculty, students, and administrators. Reducing such a complex institution to a caricature of anti-Semitic far left is intellectually dishonest and dangerously polarizing. The assertion that Harvard and numerous others are admitting students who want to rip our country apart weaponizes xenophobic and conspiratorial rhetoric, implying that foreign students pose an existential threat to the nation. This framing feeds into nativist and authoritarian narratives that seek to equate dissent, protest, or progressive activism with disloyalty or subversion. Such language echoes historic patterns of red baiting and McCarthyism, where disagreement with the government or dominant political ideology is framed as treasonous. Trump's characterization of student activism as fake anger and hate dismisses the legitimacy of protest and free speech rights on campus, core principles protected under the First Amendment. Rather than engaging with the substance of student critiques or concerns, he labels their expression as irrational and dangerous, further delegitimizing peaceful dissent. The shift in the post toward a personal attack on one of his own lawyers, demanding their resignation and disparaging their professional competence, illustrates Trump's habitual blending of personal grievance with matters of public consequence. By suggesting that this lawyer's association with Harvard should disqualify them from representing him, Trump once again demonstrates his transactional view of loyalty and governance. The call for their firing, tied explicitly to their educational affiliation rather than their legal performance, is an abuse of power rhetoric, implying that political alignment or institutional association should determine professional standing. Finally, the comment about his very big and beautiful company now run by my sons, shoehorned into the attack, underscores Trump's continued use of political platforms to promote and reference his personal business interests, a pattern that has repeatedly raised conflict of interest concerns throughout his political career. This post does not operate as serious political commentary or legitimate institutional critique. Instead, it functions as a grievance-laden, demagogic outburst that leverages fear, division, and personal vendetta. It offers no policy argument, evidence-based reasoning, or constructive path forward. Rather, it exemplifies the toxic blend of personalism, authoritarian impulse, and rhetorical irresponsibility that has defined much of Trump's political communication. Source: Truth Social. The bilateral meeting between Donald Trump and Prime Minister Jonas Gahr Støre of Norway revealed several concerning patterns in both the delivery and substance of Trump's remarks. While the meeting ostensibly aimed to address critical issues such as the war in Ukraine, U.S.-Norway trade relations, and Arctic security cooperation, Trump's commentary frequently strayed from diplomatic norms into rambling digressions, personal grievances, and speculative assertions. His communication was disorganized and often incoherent, shifting abruptly between serious matters like ceasefire negotiations and unrelated topics such as Greenland acquisition or the pricing of Easter eggs. The absence of clear transitions and the frequent use of vague statements, such as "we'll see what happens," undermined the credibility of the meeting and muddied its purpose. Trump repeatedly centered himself in the narrative, claiming that the Ukraine war would never have happened under his leadership and casting President Biden as responsible for the conflict. This revisionist framing ignores the complex geopolitical origins of the war and aligns dangerously close to Kremlin propaganda by downplaying Russian aggression and recasting the 2014 annexation of Crimea as something that was handed over by President Obama. Trump's insistence that his prior administration never even discussed the invasion with Putin is not only unverifiable but also deeply reductive given the broader international context. His repeated references to personal achievements, including the Abraham Accords and his claim to deserve a Nobel Peace Prize, further eroded the gravity of the conversation, making the event feel more like a campaign speech than a diplomatic meeting. Equally troubling was Trump's dismissive attitude toward NATO allies and the minimization of Russian obstinacy in ceasefire negotiations. While acknowledging a 30-day peace proposal that Ukraine had reportedly accepted, he hesitated to characterize Russia as the obstacle, instead blaming both sides and insisting that it takes two to tango. This false equivalency glosses over the reality that Russia is the aggressor and Ukraine the invaded party. His vague comments about applying a lot of pressure on Russia were never substantiated, and his reluctance to discuss additional sanctions or security measures if negotiations fail revealed a lack of clear strategy. The president's economic commentary during the meeting was also out of place and lacked coherence. He made unsubstantiated claims about the strength of the U.S. housing market and energy prices while insinuating that low oil prices alone could pressure Russia into peace. These remarks were disconnected from the urgent foreign policy matters at hand and instead seemed like an attempt to burnish his domestic record without regard to context. Trump's fixation on trade imbalances and tariffs, particularly his remark that Norway might be willing to pay us more, due to its sovereign wealth fund, reinforced his transactional view of diplomacy, reducing international relationships to mere financial exchanges. In contrast, Prime Minister Støre maintained diplomatic composure throughout, emphasizing shared values, mutual strategic interests, and the importance of ending the war in Ukraine. He diplomatically acknowledged the significance of U.S. leadership in pursuing peace while also reinforcing Norway's substantial military and economic support for Ukraine. Yet even his well-considered remarks were frequently drowned out by Trump's verbosity and meandering answers. In summary, this bilateral meeting illustrated President Trump's persistent difficulties with coherence, discipline, and statesmanship. Rather than advancing a clear, unified diplomatic agenda, his comments veered into political posturing, historical revisionism, and self-congratulatory tangents. At a time when lives are being lost in Ukraine and global alliances are being tested, the lack of clarity and consistency in U.S. leadership displayed here sends a troubling message to both allies and adversaries. Source: The White House. Donald Trump issued a memorandum directing an investigation into so-called and quote, straw donors and quote, and foreign contributions in American elections. The initiative is being presented as a law and order initiative aimed at election integrity. However, the document is steeped in partisan framing, selective citation of evidence, and vague legal directives that warrant significant critique on several grounds. First, the memorandum leans heavily on anecdotal claims and press reports, without specifying independent, nonpartisan sources or providing a broader evidentiary basis for the assertions. The choice to highlight ActBlue, an online fundraising platform widely used by Democratic candidates, raises immediate questions about whether this memorandum is being wielded as a political weapon rather than a neutral defense of campaign finance law. The selective mention of ActBlue without reference to comparable Republican-oriented platforms like WinRed suggests a one-sided approach rather than a good-faith effort to ensure compliance across the political spectrum. Second, while 52 U.S.C. sections 30121 and 30122 appropriately prohibit foreign contributions and straw donations, the memo conflates unproven allegations and isolated incidents into a sweeping justification for a federal investigation. The cited 22 significant fraud campaigns at ActBlue are described without meaningful context about the scale of ActBlue's operations, the comparative frequency of such incidents at other platforms, or the measures already taken by these platforms to mitigate abuse. By omitting such context, the memorandum risks exaggerating the threat to justify potentially selective enforcement. Third, the directive to the Attorney General to use all lawful authority as necessary lacks clear procedural guardrails. There is no mention of protecting the privacy of lawful donors, safeguarding due process rights, or preventing the chilling of legitimate political participation. The ambiguity of this language opens the door to abuse of investigatory power, particularly under an administration already criticized for politicizing the Department of Justice. Fourth, the timeline and reporting structure, requiring the Attorney General to report findings through the Council to the President, raise additional concerns about executive overreach and the potential for politically sensitive information to be funneled directly to the White House rather than through independent legal channels like congressional oversight or public disclosure mechanisms. Finally, the memorandum's concluding disclaimer, that it creates no enforceable rights, serves as a typical legal hedge but further underscores the document's performative nature. It suggests that the memorandum is intended more as a political signal than a substantive legal directive with measurable accountability. While the stated concern over campaign finance violations and foreign interference is legitimate, this memorandum appears less interested in fair enforcement of election law than in selectively targeting political opponents under the guise of national integrity. Its lack of balance, evidentiary rigor, and procedural transparency diminishes its credibility and invites suspicion of politically motivated enforcement. Source: White House Briefing Room. Donald Trump's executive order, strengthening probationary periods in the federal service, represents a significant restructuring of federal employment policy that ultimately raises more concerns than it resolves. Although the order is framed as a common-sense reform intended to improve the quality and efficiency of the federal workforce, its underlying approach reflects a broader ideological agenda that prioritizes managerial discretion over employee protections, weakening core principles of the merit-based civil service system. The order opens by asserting that probationary and trial periods have not been used effectively to remove underperforming federal employees, relying on a 2005 Merit Systems Protection Board report to justify sweeping changes. However, this justification leans on outdated assessments and overlooks the role of leadership accountability and evaluation training as root causes for ineffective probation management. Instead of addressing systemic management weaknesses, the order shifts the burden onto employees, fundamentally altering the balance of power between federal workers and agency leadership. A particularly troubling feature of this order is the affirmative certification requirement, which mandates that agencies must explicitly declare an employee's continued service as advancing the public interest, or else face automatic termination of that employee at the conclusion of their probationary or trial period. This reversal of presumption, placing the burden on the employee to justify their employment, runs counter to established norms of fair evaluation and due process. The order empowers agency heads with sole and exclusive discretion to determine whether an employee meets these vague standards, opening the door to arbitrary dismissals, favoritism, and potential political targeting within the federal workforce. While the order gestures toward appeal rights under procedures to be established by the Office of Personnel Management (OPM), it restricts these rights as the sole avenue for contesting termination, narrowing options for redress and leaving little room for challenging wrongful dismissal, retaliation, or discrimination. The broad authority granted to agency heads to assess whether an employee's continued service aligns with undefined organizational goals and the so-called public interest undermines the core principles of the merit system. Rather than focusing on objective performance metrics, the order invites subjective judgment, increasing the risk of inconsistent application and politicization of personnel decisions. This erosion of employment protections is particularly dangerous in the context of Trump's second-term rhetoric about purging the deep state and using federal employment decisions to enforce ideological conformity. By embedding managerial discretion at the heart of the probationary process, the order threatens to replace merit-based hiring and retention with a loyalty-based system in all but name. Beyond the legal and ethical concerns, the executive order is likely to destabilize the federal workforce by deterring skilled professionals from seeking federal employment, particularly in high-demand sectors like cybersecurity, healthcare, and scientific research. The uncertainty created by the certification requirement and the threat of automatic dismissal discourages long-term commitment to public service, undermining recruitment efforts at a time when the federal government faces persistent talent shortages. Additionally, the administrative burdens imposed by the order, such as mandatory evaluations, certification meetings, and documentation requirements, are not paired with any acknowledgement of whether agencies possess the capacity or training to execute these processes fairly and consistently. In practice, This policy does not represent meaningful reform of the probationary process but rather institutionalizes a top-down approach to workforce management that is vulnerable to abuse. Instead of promoting accountability and excellence, the order positions federal employees as disposable and subject to the whims of agency leadership. Within the broader context of the Trump administration's sustained attacks on civil service independence, this executive order appears to be less about improving government effectiveness and more about consolidating political control over the federal workforce. It marks a sharp departure from the merit-based civil service tradition, introducing instability, eroding due process, and inviting legal and ethical challenges that could weaken public trust in the integrity of federal institutions. Source: White House Briefing Room. Donald Trump signed an executive order titled, Unleashing America's Offshore Critical Minerals and Resources. This order represents yet another iteration of his administration's broader strategy of deregulation and aggressive resource extraction, framed under the familiar banners of national security and economic independence. While the order asserts the need to reduce U.S. dependence on foreign adversaries, particularly China, for critical minerals, it pushes for the rapid acceleration of seabed mining and mineral extraction without meaningfully addressing the profound environmental risks associated with such activities. The order's language about responsible development and environmental monitoring remains vague and largely superficial, taking a backseat to its central goal of streamlining permitting processes and expediting resource exploitation. By declaring seabed mineral development a national security priority, the administration invokes a justification that serves to bypass environmental safeguards and public debate. This tactic mirrors previous Trump-era policies where national security was used as a pretext for fast-tracking controversial industrial initiatives, including tariffs and energy projects. The directives focus on securing corporate dominance over seabed resources, both within U.S. waters and in international territories, raises serious concerns about regulatory overreach and the potential for geopolitical conflict. Instead of engaging constructively with multilateral frameworks like the United Nations Convention on the Law of the Sea, which the United States has not ratified, the order leans toward unilateral action, positioning U.S. corporations to benefit from mineral exploitation in contested or vulnerable regions. This approach risks being perceived as resource imperialism rather than genuine global leadership. The framing of this initiative as a counter to China's influence oversimplifies the complex geopolitical realities surrounding seabed resources. Rather than focusing on sustainable resource strategies, international cooperation, or critical mineral recycling, the policy advances a narrowly competitive, extraction-first agenda. The use of federal tools such as the Defense Production Act, public loan guarantees, and procurement authorities to subsidize private seabed mining operations further signals a willingness to prioritize corporate interests at the expense of environmental accountability and long-term strategic planning. Such provisions amount to a form of corporate welfare, funneling public resources into speculative ventures while exposing fragile marine ecosystems to potentially irreversible damage. Moreover, the order's reliance on the so-called National Energy Dominance Council, a body ideologically aligned with Trump's resource extraction priorities, underscores the directive's political rather than scientific nature. Rather than centering scientific research, ecological risk assessment, or meaningful environmental stewardship, the order constructs an overlapping web of reporting requirements aimed at facilitating industrial exploitation with minimal oversight. In sum, while the executive order purports to enhance national security and economic stability, it is better understood as a deregulatory blueprint that prioritizes corporate access to global commons, accelerates seabed exploitation, and disregards the ecological and diplomatic consequences of such a strategy. Source: White House Briefing Room. The Trump administration has admitted that Immigration and Customs Enforcement agents arrested Columbia University activist Mahmoud Khalil in March without a warrant, describing it as a warrantless arrest. Khalil's attorneys argue this illegal arrest should lead to the dismissal of his deportation case, while the Department of Homeland Security claims exigent circumstances, alleging agents believed Khalil might flee, an accusation his lawyers dispute, noting no evidence supports claims he posed a flight risk. Khalil, a Syrian-born U.S. green card holder and vocal pro-Palestinian protester at Columbia University, was detained outside his New York apartment, missing the recent birth of his son after ICE denied his temporary release request. Though the Trump administration has not charged Khalil with any crime, it is pursuing his deportation on two fronts, alleging immigration fraud related to his green card application and citing a determination by Secretary of State Marco Rubio that Khalil's presence poses adverse foreign policy consequences under a seldom-used statute. Critics argue that Khalil's case is part of a broader Trump administration crackdown on pro-Palestinian activists on U.S. campuses, framing it as retaliation against political expression protected by the First Amendment. Civil rights groups contend the administration's stated anti-Semitism justification masks efforts to silence dissent. An immigration judge in Louisiana recently allowed the government's deportation case to proceed, deferring to Rubio's determination while holding the fraud claim in abeyance. Meanwhile, Khalil's legal team is pursuing asylum and withholding of removal in immigration court and challenging the legality of his detention in federal court in New Jersey, where they are also seeking broader protections for non-citizens engaged in political protest. Source: CBS News. A federal judge in Washington, D.C., blocked key parts of Donald Trump's recent executive order on election processes, ruling that the president overstepped his authority by attempting to reshape voting laws without congressional approval. U.S. District Judge Colleen Collar-Catelli emphasized that the Constitution grants power over federal elections to Congress and the states, not the executive branch. In her 120-page opinion, she barred the administration from requiring proof of citizenship to register to vote, assessing the citizenship of public assistance recipients, and withholding federal election funds from non-compliant states. The ruling came after lawsuits filed by the Democratic National Committee (LULAC) and the NAACP challenged Trump's order, framing the dispute as a core issue of separation of powers. The judge noted the Justice Department provided little defense of Trump's actions and highlighted that Congress is already debating election-related reforms, reinforcing that any such changes must come through legislative channels. While halting most of Trump's order, the court allowed two sections to stand for now. One permitting the Department of Homeland Security and State Department to share voter database information with the Department of Government Efficiency, and another allowing the DOJ to act against states that do not require mail-in ballots to be received by Election Day. However, these were allowed solely because the plaintiffs were ruled to lack standing to challenge those specific provisions. Source: ABC News. A federal judge in Maryland, Stephanie Gallagher, has ordered the Trump administration to return a second deported individual, a Venezuelan man identified as Christian, after ruling that his removal violated a 2019 court settlement protecting certain asylum seekers. Christian, who entered the U.S. as an unaccompanied minor, is entitled to remain in the country while his asylum application is adjudicated. This ruling follows a similar order by Judge Paula Zines, who mandated the return of Kilmar Abrego Garcia, a Salvadoran national, in a case that has sparked a broader legal battle over compliance, including the threat of contempt proceedings against Trump officials. The Justice Department has argued that returning Garcia depends on the Salvadoran government's cooperation, which President Nayib Bukele has refused. Gallagher's order explicitly requires U.S. authorities to make a good-faith effort to secure Christian's release from Salvadoran custody. Immigration advocates suggest these cases may indicate a broader pattern of unlawful deportations despite legal protections. Source: The Hill. The Trump administration has asked the Supreme Court to lift a nationwide injunction blocking its ban on transgender individuals serving in the military. Solicitor General D. John Sauer argued that the injunction disregards the military's professional judgment. Opponents of the ban claim it violates the 14th Amendment's Equal Protection Clause. One of the plaintiffs, Navy Commander Emily Schilling, emphasized the issue as a matter of equal rights, not politics, noting the proven service of transgender troops over nearly a decade. The current ban is an expanded version of a policy Trump implemented during his first term, which the Supreme Court had previously upheld before being reversed under President Biden. The policy disqualifies those with gender dysphoria or those who have undergone related medical treatments. However, U.S. District Judge Benjamin Settle recently ruled against the policy, stating the government failed to justify the need for the ban with updated evidence, a decision upheld by the Ninth Circuit Court of Appeals. The administration continues to cite Pentagon claims from Trump's first term that gender dysphoria impacts military effectiveness, though courts have found these arguments unconvincing. A separate but related legal challenge is also underway in Washington, D.C. The Supreme Court has requested a response from the challengers by May 1, leaving the ban blocked for now. Source: NBC News.